Welcome to the webinar organized by San Diego State University Center for Islamic and Arabic Studies. I am the director of the center, political science professor Ahmet Kuru, and we are happy and honored to have Justice Shah with us today in this webinar. And we are all very grateful that despite his busy schedule, he accepted our invitation. And during this webinar, Justice Shah will have a presentation which was followed by Q&A. The audience will be able to write their questions in written format, and I will read them. So that's the format of the conversation. Let me start with providing a brief bio of Justice Shah. Mansoor Ali Shah is a judge in Pakistan Supreme Court. According to his seniority, Shah will serve as the Chief Justice between 2025 and 2027. Shah was educated at the Atkinson College, the University of Punjab, and Endowment College of University of Cambridge. In the Supreme Court, Justice Shah has authored decisions on constitutional law, human rights, environmental sustainability, and judicial reform. So we are honored to have him today, and without overdue, I'm giving the platform to Justice Shah.
Thank you so much, and thank you for having me over, Professor. It's been totally my honor and privilege to be a part of this webinar. I'm also, in particular, excited about the fact that I'm in the company of young people, because the future of this planet lies with them. It's their ideas, their energy, which is going to drive this planet. And I'm so happy that I'm part of this process today. And I actually think that I'll be the one learning from this event. And I look forward to all those wonderful ideas and questions that might come up. As we had agreed, the topic today is about the Supreme Court of Pakistan and how we've gone about protecting human rights. And so considering that the format that we agreed upon, I'll just briefly kind of introduce the topic, but leave a lot more space for engaging with the audience. And if they have any questions, we can talk about things. What I want to say at the very beginning is that the word human rights, which is in our constitution referred to as the fundamental rights, perhaps more rightly in the sense that it's so fundamental that these rights are so close to human beings that they cannot be taken away. So our constitution recognizes human rights as fundamental rights. And you see, it has a background. The very grundnorm, as it were, or the core constitutional value of the Constitution is that it is all about people. The entire document is to protect people. So at the heart of the Constitution lie the people, and therefore the chapter on fundamental rights could be easily called the crowning glory of the Constitution. I was just highlighting that how mainstream and how important and how central to the Constitution is the concept of fundamental rights. And you see, any institution in the country, for be it the legislature, be it the executive, be it the judiciary, we cannot move forward unless we have the very central theme of our progress is to look at protecting the fundamental rights. So there cannot be any law that's opposed to fundamental right by the parliament. There can be no executive action that sort of impinges on fundamental rights of the people. And of course, there can be no decision on our part which sort of impairs fundamental rights. All the institutions of the country have to be geared and aligned to protect fundamental rights. So central to the Constitution is the concept of fundamental rights. The entire governance, the entire legislature, the entire judiciary, the three organs of the state are structured and connected through one common theme, and that is to protect public interest and to protect fundamental rights of the people. Even we, judges at the Constitutional Court, have taken oath to protect and defend the Constitution and preserve the Constitution. So for us, we've taken a special oath which sort of then obligates us to make sure and ensure that the fundamental rights of the people are protected. So fundamental rights under our Constitution for the audience would be several, you see. For example, right to life, right to liberty, right to privacy, to property, to non-discrimination, right against slavery, forced labor, right to assemble, right to have a movement, right to association, right to information, right to fair trial, right to education, and above all, a very, very basic and perhaps the king of all rights would be the right to dignity, which is not compromisable, which cannot be negotiated. All the other rights might be subject to public interest. So my individual fundamental right is subject to a larger fundamental right of the community. But right to dignity is so inherent to humanity, so basic to human being, that it cannot be negotiated and taken away. So I think all these fundamental rights are put together and amalgamated. They come up with one right, which is right to dignity, which I think is one of the strongest rights available in the world. And we're very pleased that our constitution has come up with, our court has come up with judgments which have underlined the importance of right to dignity, and talks about the fact that no one is less than the other, that the humanity inheres, it's so basic to humanity that it cannot be taken away, and no one's life is better than any other person's life. So everybody is equal, and it inheres in a human person. You see, the dignity is so critical. So this is just a background on what we have. So as a judge at the Supreme Court, or in any constitutional court, or any other court for that matter, the basic tool to expand and progress further are these fundamental rights. So anything we do, any decision we come up with, we're guided by the fundamental rights. There's such a strong beacon and a light behind us, which helps us take us forward into deciding matters, into developing jurisprudence in the country, be it any area, be it criminal law, civil law, constitutional law. The development of law takes place deeply entrenched in fundamental rights. So that's something that I wanted to say. I can, later on, once we discuss, I can sort of refer to some of the case law that we've developed on various rights and some of the interesting examples of how we've expanded these fundamental rights from the letter of the Constitution and gone beyond that through our own ingenuity and judicial engineering, but all in the public interest.
Thank you. Thank you for this insightful introduction and emphasis. So since we announced your webinar in my universities and personal social media accounts, we received several questions, and now questions are starting to coming at this webinar too. And many people ask about minority rights in Pakistan, or in general, theoretically. They are asking about the role of courts to protect minority rights. And could you please tell us about how the judiciary in Pakistan taking a role to defend the minority rights, and what is the vision about the future protection of minority rights, basically religious minorities and some ethnic minorities?
Right. Thank you so much. That's a very important question. Let me just begin that we have reached out to defend the minority rights, and which is also a fundamental right. We've done that in various formats. Let me just begin by saying that in an interesting case that came before the courts. Can you hear me?
Yes, perfectly.
Okay. So one of the interesting cases was that a Christian, a minority in Pakistan, a Christian comes before the court and says that under the divorce law that is available to us in our personal Christian law in Pakistan, there is no such thing as a no fault divorce. You see, we have to establish adultery to divorce our partner. And he said, I don't want to make that allegation on my wife. We both just want a divorce. We just want to get out of this marriage. However, the law says that you have to first establish adultery to do this. So we examined the law, which was based in 1800s or so, which we'd inherited, and we realized that during the martial law period of General Ziaul Haq, there was a provision in the law which said that the law of the United Kingdom would continuously apply to Pakistan. Whatever changes are made in the law in the United Kingdom would automatically be incorporated in the law of divorce in Pakistan. So if there's a no default divorce, no fault divorce in England, it would automatically become a part of our personal law for Christians. However, that provision was taken away during the martial law period, perhaps to make life difficult for the minorities and to perhaps push them to come towards Islam, maybe. And this is what started happening. They started converting in order to divorce, and then they reconverted to get back to their lives, which was very sad. So that amendment made during that deviation period when constitution wasn't in place and there was a martial law, we struck down that provision, saying that that is unconstitutional, against the rights of minorities. And once we took that bar out, we said that the old law is in existence now, and the old law connects you to the law of the world, you see, of UK, which deals with no fault divorce. And after that judgment, the Christians in the countries in Pakistan can now go file divorce without any reason. And they just think that there are irreparable differences and they just want to divorce. So that's one big judgment. And since then, I'm told that there have been series of divorces that have taken place, and that has brought a lot of stability in that community. That's one. The other is we have another community called the Ahmadis in Pakistan, which have their own, they're under the constitution declared to be non-Muslims because they believe that there is a prophet after Prophet Muhammad. It is their belief. So a case came up regarding the fact that how should they practice their religion in Pakistan. And previously, it has been held that they will not, of course, call themselves as Muslims under our constitution, but they'll call themselves as Ahmadis. They would not call their place of worship a mosque because mosque is exclusive to Muslims. It will lead to a law and order situation in a community like ours. So we said they'll have to create their own place of worship. So they said, fine, they now call their place a place of worship. So the case that came up before us was a criminal case where a person walks into a Muslim walks into their place of worship and finds that there is Quran, our holy book, lying on the shelves of that place of worship. And the kalima, which is our basic tenet in Islam, was displayed on the wall. Rightly, the way the kalima is displayed, and there is Quran lying there. And this person, a Muslim, files a criminal case saying that this is blasphemy. How could they have a Quran, the holy book, in their place of worship when they're not Muslims? And how could they have a kalima on it? To which the court came to the rescue of the Ahmadis, saying that this does not constitute blasphemy, this does not this does not constitute any offense. They have all the right to read whatever they want to read in their place of worship. So their right to worship, their right to privacy cannot be interfered in. They can, in their homes or in their place of worship, read whatever. And one logic which was beyond me was that unless he reads or she reads the Quran, maybe if there ever is a conversion from an Ahmadi to a Muslim, that could only be by reading the Quran rather by not reading it, which was also very interesting. So we said no, we struck it down. We said this is not an offense. They have all the right to read, to display whatever they want to do at home in their place of worship, and that we cannot interfere. That has gone down well in the sense that that sort of brings in that tolerance that the Constitution talks about. And that's how the courts, bring in that kind of stability that the communities require, because one of our guru norms is that the society must have tolerance and must have social justice. And so by allowing a level playing field for people, by giving them due process, we make sure that people don't one community does not kind of impinge on the rights of the others. Similarly, we've also, in a recent case, made it very difficult for anybody to get up and allege blasphemy against another. In another case, in a public park, it was alleged that two Christians came forward and they were distributing material which had blasphemous content in them. And later on, when we examined the case, we realized that except few oral statements of few people, there was no evidence available. Those two Christians were sanitary workers, poor chaps working, and had gone to a public park to rest, but they probably ended up in some sort of a scuffle with some Muslims, and they alleged that these people are distributing blasphemous content. There was no such material. It was just mere statements. In past, just making such a statement would land somebody in for a blasphemy, which has severe penalty, could lead to death. And so we made it very difficult in that case that you can't just create a case of blasphemy on mere statements. There has to be a whole lot of evidence leading to this fact. There has to be a background, a history of a person leading to this. It cannot be just that overnight you just allege that this person has committed blasphemy and you just put him behind bars. So that also, I think, has pushed these things back and brought in a little more tolerance in the society that you can't just go about this. So these are some examples which are very strong to my mind, where we've really, the Supreme Court has, put its neck out to protect the minority rights. And of course, in the famous case of Asya Bibi, where she was, also in for blasphemy, the court went through a major case. It was a big political issue also, because the majority thinks that anybody who commits blasphemy, they would not listen to him, even though the other person could just satisfy the court that I never said this. I mean, don't just say this. So that case itself, we struck down the conviction. And, earlier the conviction was also because of the pressure in the community. It's very difficult for the courts at times to deal with this. So you require quite strong and brave judges to stand up and say, let's look at the evidence. Did it ever happen? And if it did, yes, she or he ought to be convicted, but not otherwise. So that conviction was also set aside. So I think the Supreme Court has reached out to protect the minority, which requires a lot more strength because they're not ordinary cases. The majority is Muslim and they just have whatever belief that they have, and then they could create pressure, which could be political in nature or social in nature. But the courts have stuck to the Constitution and have provided a lot of relief in that regard.
Thanks so much. You really give a detailed answer to the question, and I'm sure the audience will also appreciate. The questions are coming. So the next question is about the issue of environment. So as well as I know, you have a particular interest on the environment and the issues related to climate and nature. So I would like to ask about the reason for your particular interest and what do you think about the future of environmental policies and your concern and hopes about the future?
Thank you very much. You see, the background to this is that as a lawyer, I was also doing a lot of public interest litigation, even though the firm was doing a lot of corporate work. But on the side, due to personal interest, I would do a lot of public interest work. And one of the areas that I did that public interest work was to protect the environment. And this was early 90s when the thought and the concept had not come to courts. And I still remember my first public interest litigation case against vehicular air pollution in Lahore. I took it to the court, which is the High Court, and the judge said, okay, we'll talk about this fancy litigation later. Let me attend to bails and other serious matters first. So then the case came up later on, and the judge said, okay, would you undertake not to come to court in your car, and then I'll interfere? Even though I wanted to say that my car has nothing to do with the pollution, I'm talking about those rickshaws and those, twin engines and all others who are creating pollution. But there was no understanding of the court about the environment. So that's the time when we started. But later on, when I also joined the judiciary, we tried to develop the concept of environment. And it's very interesting that the entire concept of environmental justice developed around pollution that was domestic in nature. For example, a plant close by was creating pollution, or an industry around was doing that. And so there was a polluter pays principle, and there was a penalty attached to it, and you would shut down a factory, things like this. So this was environmental justice within the national domain, because the polluter was within the country, and we enforced environmental law to ensure that pollution is curbed. And so that gave rise to environmental justice. And there too, we brought in fundamental rights. And one of our major cases that came out in that time from the Supreme Court in the year 94 was Shaila Siam. Let me just tell you about that case. This lady who was pregnant at that time and an activist herself was living in Islamabad, the capital of Pakistan, and they started developing, the electric company of the state, electric corporation, started developing a heavy electric grid station in a residential area. And it was pointed out that you can't have a heavy grid station in a residential area because the high tension wires have a major effect on the development of the brain of the children, as well as have a deep effect on the people of old age. So if you have a grid station and the high tension wire is going over a already settled residential area, it will have serious effect on human life. So right to life was the touchstone on which this case went up to the Supreme Court, and the Supreme Court expanded the right to life to mean right to a healthier life, right to an unpolluted life, right to a cleaner life was the expansion of the word life. And they struck that down and they said, no, this grid station has to be taken to some other location, but cannot be set up here. So that gave rise to the concept of environmental justice. And we continued on the concept of environmental justice for a while till climate comes into picture. Now that changes everything, and we now come up in the domain of climate justice. Now this is where the polluter isn't in Pakistan, and especially countries from the south like Pakistan are not contributing to the greenhouse gases. They are suffering at the hands of the greenhouse gases that have been emitted by the West. So we just have no choice. We just stuck with the climate. I can't go ahead at the Supreme Court, punish anyone because the culprit is outside Pakistan. So what do? So we adapt to the new climate. So our policies and our jurisprudence is adaptive jurisprudence as opposed to the mitigational jurisprudence of the West. In the West, the decisions are cut down your emissions, and they're directing the state to cut down, meet the Paris Agreement, cut down the emissions. We don't have that problem. We have a multi-sectoral problem. We have a problem where our agriculture is being affected, our crops are being affected, our food security is being affected, our infrastructures are being affected, our floodplains are being affected. So we have a bigger problem dealing with climate change. So our jurisprudence is more adaptive. So while we look at any other case, we will start looking at all these multi-sectoral issues because climate change is having effect on a number of areas. So while we sit in the court looking at any case, we would have a long checklist because climate change could be affecting any sector for that matter. So for example, a cement plant, a recent case that the Supreme Court has come up with called the DG cement case, in which a cement plant was in an area which was water scarce, was being expanded. And they came up to the court and said, should this plant be expanded? Could they add on to the cement plant? And as you know, the cement plant is a water guzzler and requires a lot of water. And in that area, there was water scarcity. And so bringing in the concept of climate change into that thing, we said, no, I mean, we are already suffering at the hands of climate change. We cannot allow development which would be so imposing on the water security of the country. So we said, no, you can't have a cement plant here. You may just shift it to an area where there is some water, but not here, because of the climate change context also. And in that judgment, we brought in a new concept, was the intergenerational equity. We said the future generations are going to be affected, and this court today is responsible to provide justice to the future generations. The court also came up with the concept that nature has a personhood also. Nature must be protected. Nature has a right also to come to court, and also that we must develop the concept of dignity of nature. Dignity of humans needs to now move on to dignity of nature. because we can't just run this world through an anthropogenic system. You see, we need to think of biocentric approach to run this life. If we were to respect nature, this climate change would not have come today. Had we respected all the other, life existence around us, we would have not been where we are today. So the whole approach has to move from anthropogenic approach to a more biocentric approach, was something also that came out in that judgment. And it also talks about climate change or climate democracy. The democracies of the future need to make sure that climate is on a very important factor in their governance. So this some of the important themes that come out of this judgment. And another recent judgment regarding infrastructure development, we said that any development corporation in a country who's developing housing, who's developing roads, has to make sure that all the development in Pakistan is climate resilient. We cannot come up with developments which would impair and affect climate further, you see, and affect people. So that has been a direction given to all the corporations to make sure that every development in this country is climate resilient. So that's what we are faced right now. Pakistan faces the worst floods in the world. We've been hit by very severe floods that runs into billions of rupees, and that's not our fault. Pakistan has become a floodplain not because we've done something wrong. Maybe we have to some extent, but largely due to climate change, because the way the monsoon rains took place and the extreme weathers and the glacial melts has led to all this. So where do we now go? The cutting edge question is, where do I get this money from? I mean, if the polluter lies outside who's done this to us, who foots the bill? So there's a talk about whether at all we develop a world court now. Where do we take our matter? Do we go to the ICJ and said, listen, I mean, I haven't done this. This is a serious catastrophe that has been brought to Pakistan. I can't fix it. It's more than $50 billion. So where do I get this money? So now this is the discussion and the conversation right now for countries like Pakistan. And these floods could be repeated, God forbid. Where do we go? And how do we bring justice into this equation now? And which court do we go to? That's the debate that we need to answer sooner or later. So that's something on climate.
Thank you very much. It was really an insightful conversation on climate. And now Professor Ranin Kazemi from our history department has a question I'm reading. Thank you, Justice Shah, for your insightful introduction. I'll be interested to learn more about the history of the legal system in Pakistan and how or whether the common law from Britain and the Sharia law have been combined and harmonized in the present system. What are the strengths and disadvantages of this engagement with two different legal traditions in Pakistan? How can Pakistan teach other Muslim countries about engaging fruitfully with two different legal traditions?
Thank you so much. Well, the background is that, of course, there was common law, and we sort of inherited that through our, we were a British colony at the time, and there were laws that the British had in Pakistan. There was a constitution at that time. And we inherited the principles of common law that sort of came into our own statutes. So we had our own constitution. This is the third constitution we have now. So we have our own constitution. We have legislated the laws in Pakistan. So there is no, the background being common law country, but it's all statutory scheme of laws that we have. We have, through our parliament, brought in, because our constitution starts off by saying that the sovereignty over the entire universe belongs to Almighty Allah alone. So it's all the Islamic dispensation which comes into our system. So the parliament is the key authority which would debate the laws and see whether at all they comply with the Sharia, and they keep introducing that legislation, which is just fine. It just keeps coming in. However, there is a court called the Federal Shariat Court, which has been created under the Constitution, that if somebody feels that a provision is not Islamic or is against Islam, that provision can be separately challenged in that court, which has Islamic jurists sitting there along with judges who would examine that law and see whether at all it passes the test of Islam or not. So that's a separate court that's been constituted. Its appeal goes to the Supreme Court Shariat Appellate Bench. But other than that, for us, we just enforce the laws that come out of the parliament. It is the parliament where debate takes place. And I think the amalgamation has been rather smooth. Most of our laws now have the Islamic dispensation that has come into it, and we enforce that law as it comes. We don't have to take up that issue in the court because we're not trained in that area. That's not our business to start second guessing the law on the basis of Islam, or we just see the letter of the law the way it is and implement the constitution in as progressive form as we can. But the responsibility lies in the parliament to bring in that merger, to bring in that kind of assimilation of thoughts from all sectors, bringing in Islam and incorporating them in the law, and that has happened over the years slowly. And most of our laws are now compliant with the Sharia law, and so that's how it works, and it has worked rather well. If there are certain rough edges, they are taken to the Federal Sharia Court for examination and review.
Thank you. And Farah Hadid from our Department of Political Science master student, he is asking about the human rights cell in the courts and how individuals can apply to the court for human rights abuses, and who can individuals apply to the court on the issue of human rights?
That's an interesting question. I might have a slightly different view from what the system is in the country. There is a human rights cell that has been created only in the Supreme Court. And this entertains applications relating to violations of human rights. And the process was that they would either put that up before the court for the court to examine. Let me also say that we in Pakistan enjoy a very unique power. When I say we talk about the Supreme Court, called the suo motu power. Now, the suo motu power is where the court can take action on its own motion. Nobody needs to approach the court. The court could just take up a matter if they think that matter pertains to fundamental rights or violation thereof, and interfere in the matter. In the past, to my mind, this power has been abused also. My understanding of this power, which is rather unlimited, is that it has to be very cautiously applied because it gives the right to the highest court in the land to take up any matter that the court wants. So how is the matter to be taken up is one question. It has to be more collective process or participatory process at the Supreme Court to decide whether at all we have to take it up. And to my mind, with great respect to the Chief Justice of the times, it cannot be a power given to an individual to decide. It must be a collective power. And secondly, it must be very clear on what areas do we exercise suo motu powers. To my mind, it can only be to enforce fundamental rights, and only where a depressed class or a community which cannot come to court is reached out by the court to help and assist the community. It cannot be in any other matter for that matter, because there are other remedies available in the country to deal with these issues. And so suo motu power has to be rather carefully enforced. Now, the Human Rights Cell, which was established, is an administrative body, which I personally have a serious disagreement with, because our court cannot have two parallel jurisdictions. You have a petition, you come to us straight away to the court. You can't go to our administrative cell and go to some administrative officer in the court who starts examining applications and passes some sort of directions or get some orders on that, as if we are running a parallel system to it. I think the best way to look at it is that, yes, people could apply to us, bring to our notice that there are things happening which are relating to the violations of human rights, and that matter needs to be put up before the court. And if the court thinks that it requires judicial intervention, then the court takes it up as a case. But currently, the Human Rights Cell looks into the matters and at times administratively passes certain directions to pacify and help those causes, which conceptually I have a problem with, because we are not in the business of passing administrative orders. We are only in the business of passing judicial orders. So that little cell, that little administrative forum that we've opened cannot function on its own. It must be dovetailed into the court, and only through a judicial order could we solve that problem. But currently, yes, we have a human rights cell at the Supreme Court which entertains applications, examines them, and passes some administrative directions to pacify those issues. And if it's a serious matter, it comes to the court. That's how it is.
Thank you. And another question which is important for American audience is to understand the relationship between the branches of government in Pakistan, the judiciary, the parliament, and the government. And could you please help us understand how the system work and what is the connection between parliament, government, and judiciary in Pakistan?
Thank you very much. We work on the principle of separation of powers. There are three different, totally isolated organs of the state, of the government. Uh, Judiciary has a totally insulated and a separate cadre and a system. So does the executive, and so does the legislature. So the executive is part of the legislature, but as far as judiciary is concerned, they're separate. And over the years, our jurisprudence also underlines that the separation of powers has to be maintained. The judiciary cannot get into the powers of the executive or exercise the powers of the executive. In fact, recently we've come up with a judgment where we thought that a high court, had gone in and meddled into the affairs of the executive and assumed the role of the executive, to which we refer to as judicial overreach. While judicial activism and judicial restraint is something that we always exercise, depending on the judge, he could be exercising judicial restraint or could be more progressive and have a judicial activist approach. That is within the domain of our jurisdiction, but we cannot commit judicial overreach, which underlines the fact that we are separate. Every separation of powers is a key principle, a constitutional principle to be followed. The judiciary minds its own business, it interprets the law, enforces fundamental rights. Executive goes ahead and enforces the laws and runs the country, whereas the legislature comes up with the laws and legislate laws. So as far as Pakistan is concerned, there are three different areas altogether. Judiciary does not mix with them. We do not have cross transfers like in the US. We don't have executives coming into the judiciary. Judiciary is a totally separate institution. And so these walls are very clear, and the walls of separation are very clear also.
Thank you. So there are three questions about the elite versus mass distinction. And let me combine and briefly ask you that the argument is that in Pakistan, there are the elite who has political power and wealth and the ordinary people. And then do you think judiciary should or does play a role to shrink the gap between the elite and the masses? And do you think there is any role for judiciary on this matter?
Of this, I think the judiciary, the role is only of the judiciary in this matter. As I had said earlier, the very purpose of the judiciary is to maintain balance between different power groups in the country. So the mighty cannot step on the ordinary person or ordinary citizen of Pakistan, and that's where the judiciary comes in to bring in that balance. This intervention is not easy. It's easy said, but very difficult to maintain, depending on who are the relevant players. So ordinarily, we see that as far as the executive is concerned, as far as the government of the day is concerned, we strike down their notifications, their decisions at times, which we think are impairing on the rights of the fundamental rights of ordinary person, which is where the judiciary plays a very effective role every day. And that's what we call judicial review or administrative law, where we ensure that an ordinary person is not subject to the excesses of the government. The other dimension Pakistan has is the military establishment, which has a very strong role to play over the years. And there things get a bit murky, you see, where perhaps judiciary does not at times enforce itself in the same fashion, but that was in the past. I think the judiciary of today is very active. The judiciary of today is maintaining that balance as per the constitution. The judiciary has to follow the constitution and is trying its best to do that. And it does not matter if it's the military establishment or is it the executive, it does not matter. Everybody is under the law, and the judiciary ensures that everybody gets its right place under the law. So if an ordinary person is being harmed by any establishment for that matter, and there is a clear violation of the fundamental rights, the judiciary will interfere. And it is our obligation, we've taken an oath, and it is an obligation under our constitution to ensure the constitution is enforced and the fundamental rights are implemented irrespective who is appearing before us, be it the military establishment or be the executive. So that's very clear. The lines are very clear. The judiciary is certainly there to ensure that an ordinary person is not harmed, and nobody takes away the rights of an ordinary person, be it be any force from the other side. That is the role of the judiciary. And I think compared to other countries, because in our countries the political situation had been turbulent over the years, the role of a judge in our democracy is not only just competence and intelligence and knowledge of the laws, but there is courage which is required of our judges, because to speak truth to power, you require courage. So in Pakistan, an additional quality a judge must have is that he must be courageous to follow the constitution, irrespective of whatever parties appear before it. And I'm quite sure that the constitution and the Supreme Court today is in that frame of mind and heading in that direction.
Thank you very much. In fact, there were two questions about the military. I was planning to avoid them for not putting you in a risky position, but
no, it's I mean, no. It doesn't. I wanted to say that because we respect all our institutions. I think military is a fine institution in this country, one of the most well-organized institutions. Great respect for that. It is there to protect us and provide us security against international, in any sort of international pressure. But the question, as far as the courts are concerned, to us, everybody is equal. And all we need to do is follow the constitution. So there's nothing against the military establishment, nothing against the government, nothing against the people. We just follow the constitution, and that makes life very easy for everybody. And that's what the scheme of the constitution is. And that's the only way to bring balance in the society and ensure that democracy progresses.
Thank you very much. So, Justice Shah, I know that your schedule, you have another meeting to attend after the webinar. So maybe I can end with your vision about the main topic of the webinar, the protection of fundamental rights and liberties in Pakistan. And the audience will be really willing to hear your concluding remarks about your vision about the protection of rights and liberties in Pakistan.
Thank you very much for this webinar and the wonderful questions. Well, I would just like to say that the key purpose for which the Supreme Court is there, or any court is there in this country, is to enforce the fundamental rights of the people and ensure that there is a balance, there is tolerance, and there's stability in the country. And the courts will always endeavor to do that. And every constitutional court is under an obligation to enforce the constitutional values as well as the fundamental rights of the people, come what may. And that's what we're here to do. And inshallah, we hope that the Supreme Court will always stand up and follow the Constitution and enforce the fundamental rights of the people, because that is perhaps the key function of the Supreme Court. And that automatically sort of brings the Constitution falls in place, and everybody gets whatever is their due under the law. So that's what I would like to say, that the Supreme Court of Pakistan is determined to follow the Constitution and to enforce the fundamental rights, come what may. Thank you.
Thank you very much. And let me tell you that we are looking forward to have you in person when you visit United States. And for the audience, in 45 minutes, we have discussed fundamental rights, environmental issues, the relations between the branches of the government. And Justice Shah also mentioned the issue of the armed forces and the judicial relations. And it's an honor, sir, and we are happy to have this conversation and thankful to you, and hope to see you in future in person in San Diego.
Inshallah. Thank you so much for having me with you all. It's been such a pleasure. It's such an honor for me to be a part of this webinar. Thank you so much.
Thank you. For the audience, we will put the video of this conversation on YouTube. You can watch fully and share with your friends and others. And have a good one.
Thank you.
And then keep in touch. Thank you. Bye-bye.
Thank you so much.